When I was in Rome, in fact, at the gift shop of the Capitoline Museum, shout out to Cicero, I saw this cute little book titled Rome Infographics. It had a bunch of neat charts about ancient Rome. Like, ancient Rome is my passion, so I thought it was so cool. Until I saw the part about the judicial process. The first warning sign is that it said the judicial process singular instead of the judicial processes plural, because of course there are many different procedures depending on the type of law, the time period, the place, even sometimes the social class of the people involved. But let's breathe for a second and look at the first step. The plaintiff goes to the accused plus the lawyer. Why doesn't the plaintiff get a lawyer too? Do they all have to be pro se? I guess that's one way to do tort reform. But no, the plaintiff can have counsel too. Look at the pro quinctio. It's a speech that Cicero made representing the plaintiff. How about the pro Caecina? That too. And then they go to the magistrate, and there is either an agreement by which the process ends, or the accusation is upheld, and then the case is brought before a judge. Actually, there is a third option where the magistrate can go, dude, you don't have a case here, and then stop it there. And anyway, it's a little weird to get an agreement at this stage. Like, if you're already at the urban preter trying to put together a formula, I don't know why you'd suddenly get to an agreement. I guess certainly the nightmare of waiting hours and hours in line to see him would make anyone want to settle, so I could see it happen, but maybe a bit earlier. I can already tell what type of procedure they're trying to depict. If you have the plaintiff and the defendant, and they go to the magistrate, and then they go to a separate single judge, that screams formulary unus iudex procedure, which was the most common for civil cases in the late Republic and the early Empire. They usually deal with like the lower type of cases, like a big inheritance case would use the centum viral court, which is called centum viral because it means centum, 100, viral like men, 100 men, because at some point in time, like it's a civil jury court. It's like a set of 4 civil jury courts, and at some point in time, if you added all the juries together, you'd get like 100 jurors. But then they changed the number of jurors, and now if you add them all together, like in the later times, like in the Empire, if you added them all together, you get 180, so it was like the 180 court. And there's also recuperatores, which was like a smaller panel of judges, like 3 or 5, and like the Caecina case with Cicero used them, and they were used for stuff like injury and other cases too. But what I don't like is like how they just say, oh, this is the judicial process, and when it's just one of many. And remember how I said civil case? Yeah, that will be important pretty soon. Like, you gotta understand that like this is not a criminal procedure. Like, this is the sort of thing you use if like you're just chilling in ancient Rome, and then like your neighbor comes over and kills your chicken, and then you're kind of mad, and you go to your neighbor and you're like, hey, pay me back for my chicken, and your neighbor's like, what chicken? And I'm like, I saw you kill my chicken, and your neighbor's like, bro, I didn't do it, man. And then you're like, I'm gonna take you to court, and then he's like, well, I'm gonna fight it, and then you go to the magistrate to do this type of procedure. If it's like a murder, or electoral malpractice, or bribery, or extortion, or public violence, or all those other stuff, this isn't the procedure that's used. But that's enough. Let's go back to the infographic. Now we get the judgment. Guilty or not guilty. The guilty leads to a skull or a bag of money, which I assume represents capital or subcapital punishment. Remember how I said that this was clearly a type of civil procedure? Now, I don't know about other types of law. I don't know what people do today. I only know about Roman law, but I can tell you that in Roman law, there is no type of civil procedure that includes the defendant getting the death penalty. The unus iudex procedure is not used for criminal law. You can't just combine the two. Maybe that's what they meant by singular judicial process. You get like the civil processes, get like the criminal processes, you make one, and you're like, wow, that's a judicial process. But it doesn't work that way, because none of the processes work this way. But that's not all. Guilty also leads to the appeal to the people. This is the provocatium ad populum, which is more or less defined by the legal right of a citizen to challenge a magistrate's unilateral decision to give them the death penalty or corporal punishment or something like that, by instead having a proper trial in front of the people. This is not a I lost a lawsuit type of appeal. This is more like a my rights have been taken away from me, like, someone help type of appeal. Well, I guess if you were being sued and then the judge tried to give you the death penalty, maybe then you do need an appeal to the people. But I think maybe prosecuting the judge for murder would be a better choice. We are almost there, and it does not get any better. Not guilty leads to the plaintiff being accused with calumny, which is making a false accusation. Okay, so the plaintiff loses a lawsuit and they get instant criminal charges. That's another way to do tort reform. Now, I have to mention the difference between suing someone and losing and making malicious and false criminal charges, which is what calumny is. Fun fact, there's a difference. Sometimes the plaintiff, or even both sides, would have to put some money on the table, which would be forfeit if they lost, to discourage frivolous litigation. But that's a bit different than being charged with calumnia, which is an actual crime that exists and is also very, very misunderstood. For some reason, a lot of people think that if the prosecution in a criminal case lost, they were instantly charged with calumnia, but they aren't, because failing to prove someone guilty is different from making false and malicious criminal charges. It's misunderstood. As misunderstood as the Roman judicial process is, if I may add. And by the way, the punishment of calumnia is not being branded on the forehead. No, why would they do that? And this book has a bibliography, but I didn't find anything about Roman law, which makes a lot of sense.